And welcome back, everybody, to the Law and Crime Network. I'm your host for this afternoon, Rachel Stockman, and boy, that must have been the fastest deliberations in Florida's history. Just under about 15 minutes, and the jurors in the Donald Smith murder trial that's happening in the Florida area came back with a guilty verdict on all counts. No huge surprise here. The case moves into the death penalty phase starting on Tuesday. And of course, we will be covering that, giving you gavel to gavel live coverage of what's happening in court. I want to bring my guest, Gary Gerstenfeld, who's a criminal defense attorney. He's joining us via Skype. Gary, that was a pretty fast deliberations there. Are you surprised?
15 minutes, yeah. I mean, I wasn't surprised on the verdict. But typically what happens is jurors go back, and sometimes they'll do what's called a straw vote, where they just sort of try to figure out where everybody's head's at. Obviously, in a case like this, you know, they probably went all around the room, and clearly that straw vote became the vote. But 15 minutes, that's a fairly quick verdict.
I mean, they must have just had time to pick a foreman, and that was about it, because I'm sure they went into that deliberation room knowing exactly what they were going to do. Here's my question to you, Gary, and I've been trying to understand this as we watch this trial unfold. Why the heck did Donald Smith take this trial, go to trial with this case? Why did he make that strategic legal decision?
Well, to be candid with you, you know, sometimes you go where your client wants you to go, sometimes in a direction you don't want to go. I mean, I feel bad for the poor lawyer sitting there next to this guy, watching the plane crash and knowing there's really a whole lot, nothing he can do about it. So, look, I don't think anybody feels anything for Smith, but I feel something for that poor defense attorney who had to, fly that plane. So why would you take a case that's a dog to trial? Well, sometimes what you're trying to do is use the trial for mitigation. In other words, try to show there's some redeeming quality about the person because you know you're going to be convicted, but maybe there's some part of the story that might be sympathetic and you won't be able to get that out in a plea. But in this case, that didn't happen either. As a matter of fact, if anything, it probably further illustrates more about who Mr. Smith is in such a bad light that I think now it's even more of a challenge now that we're here in this phase where we're talking about whether we spare his life or he spends the rest of his life in prison.
Well, I kind of had a suspicion throughout all of this. Going into the trial, I thought it was really because he was, like you kind of indicated, trying to spare his life, and
right.
That's why he ended up taking this to trial. But as I watched what happened in court, I really started to believe that maybe it was because he just liked the attention he was getting with cameras in the courtroom. There was a picture that we actually have from yesterday where I think we can pull it up, where he was actually posing for the pool camera. There it is right there. There you can see. I mean, he didn't smile or anything, but point is, he saw a camera taking a photo of him, and he kind of made himself more available for the camera. Like, you want a shot at me? Here I am. Okay. Is this guy some kind of sick pervert that just likes the attention out of all this as well?
It's hard to get into the head of somebody who is a true sociopath. It's hard to understand exactly what motivates them. But yeah, I assume getting attention, being in a courtroom is probably more entertaining than sitting in a cell and staring at four walls. So perhaps that gave him some interest. But I suspect too, there's always this part of you that thinks somehow that you might be able to get away with it. I mean, don't forget, Mr. Smith has a long history of trying to get away with things. And so who knows? Maybe he felt if he went to trial, maybe the witnesses might fall apart, maybe something might happen. I mean, it always amazes me how people will have a case where the evidence is so compelling and yet still think that if they take the case to trial, somehow something's going to come good out of it, that they'll get a break or something will fall apart. I mean, this is a case where the state had, all their ducks in a row from the very beginning. It was a very streamlined case. They knew what they needed to do, and they were able to put their witnesses on. They got through the case fairly quickly, and there was really no defense whatsoever. So This was,
Well,
yeah.
there really wasn't. No witnesses presented by the defense, no closing. Now, the defense did do an opening, and I will tell you a lot of our legal commentators that we had on really railed the defense attorney for how she presented her opening statement, and that was because she really took aim at the mother of Cherish Periwinkle, that poor little 8-year-old girl that was subject to all of this, trying to paint the mother as a bad mother that really left her daughter vulnerable. As a criminal defense attorney, how do you view that? Would you have taken that tack? Do you think it was a strategic mistake, or in the end it didn't really matter?
Well, I think it's both. So yeah, I think certainly it is a strategic mistake. Yes, going after widows and orphans is always a bad idea. Blaming the victim and that sort of thing. Yeah, I mean, certainly if you're trying to make the jury dislike your side, start off by attacking the victim's mother, who had nothing to do with the death. Yes, that's probably a bad start. Why? I don't know. Not putting on a closing. Not. Again, when you get a case, the first thing you need to decide is whether it's a triable case or it's not a triable case. Then you decide, well, okay, it's not a triable case. Maybe there's some things here that might, get a lesser sentence. Maybe get some. Maybe you've got 20 counts. I remember with the Enron case, the defense attorneys came out very proud and said, we won so many of these counts. Well, I mean, he got life. He got life in prison. But there were some not guilties across the board of all these counts that were charged. And maybe you might take a case on hoping that you can somehow beat some of the counts, some of the charges, do something. In this case, not cross-examining witnesses, not putting on any kind of defense, not doing closing. Those things are rank amateur. I don't understand why that would happen. And then starting off by attacking, again, widows and orphans.
Yeah, it was. I agree with you. I think it was a really poor defense strategy. It's going to be really interesting as we move forward to the death penalty phase of this case, which starts on Tuesday. In this scenario, what do you do as a defense attorney to spare this guy's life? Because as many of us have said in the newsroom, if there's ever a case where you want to put someone to death, it's a child molester that raped, sodomized, and killed an 8-year-old. What do you do? What do you do to avoid the death penalty here?
And then bragged about it.
Don't
forget about the bragging part. And you bragged about it.
He did.
Well, in baseball, sometimes we have what's called a pitch hitter. So, I would hope at some point maybe bringing in some additional help, because clearly the tack that you made through the trial didn't work. Now you need to do mitigation. A psychosexual evaluation would be helpful. Getting some experts on to testify about his situation, about his psychological situation. He was brutalized as a child. He had problems in his life that could possibly explain this kind of behavior. What are you trying to do? I mean, he's doing life without parole. That's a non-issue. That's so he either dies in a box or he gets the needle. Those are his two options. And so from a defense attorney's point of view, maybe you try to hit the jury with do we put people to death who have mental problems? Do we put people to death who are sociopaths because of some horrible experience they've had in their life that, doesn't justify the behavior, but also justifies us finding the leniency not to put that person to death? That would be the most appropriate tack to take.
But of course, that's it's a question that the jurors are asked before they're qualified for a death penalty case. Could you put someone to death? And the attorneys, the prosecutors, try to weed out the people that are just fundamentally against the death penalty and regardless of the situation would vote against it. So it's certainly going to be very interesting to see what happens when this trial resumes on Tuesday with the death penalty phase. So Gary, you talked a little bit about bragging, about how this man, Donald Smith, bragged about what he had done. And there was actually, and I think this is what you're referring to, a secret recording that was recorded at jail where you can hear this man talking about these things, and it's just sickening. I want to play some of that recording, and we'll keep you on the line to discuss it.
Detective Carter, the voice that you just heard that said the one in the back, is that the inmate who was housed directly adjacent to the defendant, Donald Smith?
Yes, sir.
Second voice that's on that recording, is that the voice of Donald Smith?
Yes, sir.
Okay, the person who said they're about 12.
Yes, sir.
Yeah. You still think she's 12? Yeah. That's right in my alley right there. That's my target area right there. That's what I go after. Well, you have fun with that one.
Officer Carter, the person who said, that's my target area, that's what I go after, whose voice is that?
The defendants.
You still think she's 12? Yeah. That's right in my alley right there. That's my target area right there. That's what I go after. Well, you have fun with that one. See, her office would be ashamed here. Yeah. Letting that girl run out looking like that, man, with fake eyelashes, fake fucking nails, fake hair, fake titties probably. Yeah, I'd like to run into her at Walmart.
Officer Carter, the voice that just said, I'd like to run into her at Walmart, is that the voice of the defendant?
Yes, sir.
That hair is ridiculous. Straight fucking ridiculous. Cherry has a foot on her? Yeah? Damn, boy.
Let me just inquire, the voice that we just heard that said, Cherish have some butt on her, that was not this defendant, correct?
Yes, sir.
That was the other inmate in the adjacent cell.
Yes, sir.
She ain't acting like that, though. That's because she ain't black. She had a lot for a white girl.
The last voice that was depicted there that said, because she ain't black, but she had a lot for a white girl, was that the voice of this defendant?
Yes, sir.
Officer Carter, this recording was made 2 years after the defendant was arrested, wasn't it?
Yes, sir.
Thank you. I don't have any further questions.
And welcome back, everybody, to the Law and Crime Network. I'm your host this afternoon, Rachel Stockman, and we had a very, very busy day in court this morning. We saw closing arguments in the case of Florida versus Donald Smith, who was convicted. The jurors took just 15 minutes to deliberate before convicting this man of kidnapping, raping, and killing this 8-year-old little girl, this poor little girl that was taken from a Walmart several years ago. It's a horrifying story, and we were just listening to some audio from inside a jail that was secretly recorded. I'm here via Skype with Gary Gerstenfeld, who's a criminal defense attorney. When you were listening to some of that secret jail recording, what was going through your head, Gary?
The size of the needle.
Yeah.
Oh boy, it's boasting like that. It's going to be a problem.
Could that spell his death right there? I mean, besides what we heard from the medical examiner who went through detail by detail yesterday morning of what this little girl endured, that was hard enough and sick enough to listen to. But then this.
Well, exactly. And, when we talk about the death penalty and defending against the death penalty, what we're talking about is the idea of redemption. We're talking about the idea that, yes, this person did a terrible thing, but this person has some quality about them that makes sparing their life an important force that we have to take into consideration. The idea that our sense of humanity recognizes and connects with that sense of humanity still in that individual. And therefore, while we acknowledge the terrible thing they've done and make no bones about it, we resist the urge to, apply Sharia law and simply kill them. Rather, we apply the idea of mercy. The problem is when you hear that kind of conversation, again, this is unrehearsed, this is him in his natural state, and we get a glimpse into his character, and we get a glimpse of who this person truly is. It's hard at that point to find the mercy that trying to connect with the jury, and we're trying to somehow find that moment of sensitivity to your client, his situation, where he is and who he is, to find that opportunity to avoid the death penalty. In a case like this, it's like a freight train running right in the direction of. It's tough. It is really, really tough. I mean, glad I'm not that defense attorney.
Absolutely, and it's so interesting, to try to get some of the insight into the dynamics. I would love to be a fly in the wall of the room of Donald Smith and his defense attorney. What did he tell her? How did that all go down? Would certainly be very interesting to see. So if you're just joining us here on the Law and Crime Network, we had a very action-packed day this morning. Jurors deliberated for all of 15 minutes in the Florida versus Donald Smith case and found him guilty on all counts of killing that beautiful 8-year-old little girl that you've seen her picture over and over again here on the network. It's so heartbreaking every time you see her. What's up next? Well, the judge announced at the end of the verdict there that they would reconvene Tuesday morning for the death penalty phase of this case. Of course, we will bring it to you live here on the Law and Crime Network. And we are also following another case out of Florida, very, very interesting case, and that is the Bob Ward case. He's facing second-degree murder charges for the killing of his wife, Diane. Now, he was convicted once, but he had his conviction overturned because a higher court found some errors in what the prosecutors had done in the previous trial. Gary, have you looked a little bit into this case? Because as far as I know right now, it looks like we're going into closing. So this thing's about to be over. We could see closings this afternoon. What direction do you think it's heading? Because I had no doubt in the Donald Smith case where we're going with this. But this one, I think there's some questions. What do you think?
Well, the problem always about the dead husband, the dead wife, is we always look to the one that survived and say, there you go, there's your target. So the biggest challenge always is, if not this person, then whom? Because there's no question in the case of Bob Ward, there's no question that, it's a homicide. So then the question is, all right, it's a homicide. We've got now who's the most likely suspect? What's the evidence? And then how do we counter that evidence? Biggest problem I think Mr. Ward is going to have in terms of mounting his argument is how strong is his defense for denial, because he is obviously the most likely suspect.
And we had so the crux of his defense really relies on the fact that the wife, Diane, was having, some mental issues. She was intoxicated. She couldn't control herself, and that there was a struggle, and he was trying to get the gun out of her hand. They put some witnesses on the stand, one a friend who basically testified to the fact at some kind of social gathering she had gotten really aggressive with him. It gets into some murky area, but are there some red flags here that point you in the direction that this could in fact be murder?
The history of the couple, the fighting they've had in the past. Again, when you talk about alcohol and drug, that tends to exaggerate everybody's emotions, everybody's behavior. And then, is it a self-defense? Is this, is there a plausible explanation? The good thing for Mr. Ward always is that the standard of proof is reasonable doubt. So the jury can go back with their suspicions. The jury can go back and say, boy, I'll tell you, I think it's murder. I'm pretty sure it's a homicide. I'm pretty sure that this guy, he's not being totally straight. But that's not enough for a conviction. There has to be an absolute, in terms of what is beyond a reasonable doubt, think of it as a traffic. When you see a green light, you go through the light. You don't really pay attention to what's at the intersection because you assume, hey, the other guy's got a red light, he's going to stop. It doesn't always happen. But for the most part, we go through green lights. We rely on that. We're talking about reasonable doubt. It's the same thing. Is this case where there's a strong light, or is it not quite so red? And that's the problem the prosecutor's going to have, and that's the argument the defense is going to make.
And of course, part of the motivation, I think the prosecution did a pretty good job of trying to articulate what would motivate Mr. Ward to shoot his wife, and that they contend is that there was a bankruptcy proceeding where Diane Ward was going to testify at, and apparently he wasn't very happy that she was going to do that and what she was going to say. I don't know, though, there's still some questions in my mind about all of this. I don't think anyone to do something so premeditated like this. It just seems like from the description of what happened, of course we're only getting one view of it, that it just was kind of a drunken mess.
Motive, of course, motive is not an element of the crime, but motive explains why people do what it is they do. And the argument is, hey, this was a bankruptcy and I didn't want this person. Is that enough to justify someone committing murder? I mean, most people in a rational, sane mind, of course not. I mean, bankruptcy, whatever happens. It's the lawyers. And, there's more elements in that typically than what person going through bankruptcy really understands. It's a lot of paper, and it can be very confusing. I don't think that that's a strong motivation in and of itself. I think the history of frustration and anger that existed in this relationship, there was a dynamic that certainly may have been acted onto by the bankruptcy, but that's not a motivation. Insurance policies, new girlfriends, new loves in your life, those are motivations. This is not a strong motive case. And again, too, with the alcohol, it's hard to fully understand what was going through anybody's mind at that moment because everybody's drunk.
Right.
With that, you got anger and you got people losing their temper. And of course, there's always a gun. It doesn't take much when you got a gun in the story. So, add a history of problems, add a history of not thinking through consequences, problems in the relationship pre-existing, bankruptcy, things are a lot of personal failures, things aren't going right. And, you add that to the story, and then let's throw a gun into the mix and see what happens. Again, from the prosecutor's standpoint, they got to show, hey, this was, a strong red light or a strong green light or whatever it is. Their point is that, they've got to hit that standard beyond a reasonable doubt, which again, that's a tough standard.
Absolutely. Well, we'll be monitoring that case closely. It's supposed to resume again this afternoon. We're going to be looking forward to seeing those closing arguments and how the defense kinds of wraps up the entire case, puts it in a package so that those jurors can digest it as they go into that deliberation room, because we know how important those closing arguments are, especially when you have a case that goes on for a while. This one wasn't exceedingly long, but has so many different components to it and so many different theories. So we'll be on standby mode for that. I did want to mention again that we had a busy morning this morning, in that jurors deliberated for about 15 minutes and found Donald Smith guilty of 5 counts, of multiple counts, including murder, kidnapping, and sexual assault of the 8-year-old little girl. It's a case that we've been following very closely here on the network. This morning, we watched some of the prosecutors' closing arguments, and I think they were very strong. If you missed them this morning, I want to replay them now.
Ladies and gentlemen of the jury, Cherish Periwinkle was 8 years old, and she weighed 67 pounds. She was 8 years old and weighed 67 pounds. As this defendant sits here in his courtroom today, he may not look like much of a threat in his shirt, in his tie. But on that night, in comparison to that little girl, he had the strength of a giant. He selected her. He lured her away from her family and safety. He made her feel safe through his lies and his deception. And then he preyed upon her. He drove out of that parking lot of the Walmart to where no eyes could see and no ears could hear. And then that little girl had to endure a nightmare no child should ever have to endure. She was gagged so forcefully that her gums bled, her lips tore, her nose was bruised. Him trying to silence her screams. He raped her. He sodomized her. He tore her apart. He sucked on her breast. He made her suck his penis. He left behind semen in her mouth and in every part of her private area. And then he took something, we don't know what. He wrapped it around that little girl's neck and he strangled the life out of her. He strangled her so hard that the blood vessels in her face burst. Her eyes hemorrhaged because she fought. Dr. Rao said it took minutes, depending on how she fought back, but you could tell through the damage in her eyes that she fought until the last breath left her body. And he silenced her. And then he took her and waded into the water, entombed her in that watery grave, hoping that no one would find her, hoping that no one would see what he did. In opening statement, The defense attorneys accused us of trying to anger you. And I submit to you, ladies and gentlemen, that if you have anger inside of you, it's not because of what I said or what Ms. Nelson said. It's because of what you saw. It's because of what he did. But the court will instruct you later on. Because your verdict should not be based upon emotion. It should not be based upon anger. Let me read to you the instruction that you will hear later on today. This case must not be decided for or against anyone because you feel sorry for anyone or because you are angry at anyone. Your verdict in this case should be based upon the legal analysis of the facts. The facts as you see them. The facts as you find them.
All right, welcome back, everybody, to the Law&Crime Network. I'm your host for this afternoon, Rachel Stockman, and you're just listening to some of the closing arguments in the Donald Smith case, a case that we've been following out of Florida, about a man who has now been convicted, a sex offender who snatched up an 8-year-old little girl, beautiful Cherry Periwinkle, from a Walmart in the Florida area, raped her, sodomized her, brutalized her in ways that are just, quite frankly, unspeakable, and then left her for dead. Horrible story. I'm here along with my guest for the afternoon, Gary. And Gary, what did you make of the prosecution's closing? I mean, listen, this wasn't a hard case for him to prove.
Right. Well, yeah, okay, first of all, he's awful. I mean...
You don't mince words, huh, Gary?
it's hard to watch. I'm trying to get back in the camera here. I know as I'm floating around. He's terrible. He's talking very slowly. There's no reason to that. He's got the glasses on. He's got the glasses off. I don't know what that's all about. He's turning his back, and he's taking his time. There's no reason to. I mean, this is the perfect elements. Here's the case. The guy is a child molester. Ooh. He sodomizes and murders an 8-year-old child. He brags about it in a jail cell. He's a terrible human being. The elements of the crime are all there. He, do your thing.
You mean be more dramatic? He was too slow, is what you're saying.
Look. The problem with being dramatic sometimes is this: once you've rehearsed being dramatic, it sounds rehearsed, and he doesn't want to do that. And he's trying to give this the gravitas that he thinks the case needs. So he's trying to come across as somebody who is learned and thoughtful about it. This is the state talking. So he's trying to give the impression that this is a considered thing. But he's going slow, and he's taking time, and he's trying to show what was in the look. The guy's a child molester. He does a terrible, horrible crime. You can't even talk about the last hour of life in this child is something that it's unspeakable. It's horrible, and he's an evil human being. At no point do I hear the prosecutor look at the guy and go, "This is evil. You want to see evil in a nutshell? This is evil. It doesn't get more evil. This is the guy." Okay, that's what you need to do. Hit him with the facts. Hit him with reality, and don't mince words.
So Gary, you're a barred attorney in the Maryland area, and you just called this prosecutor in Florida awful. So I certainly hope that you won't have any cases that you have to defend someone in the Florida area, because I hope he didn't see that. He wouldn't be too pleased with your description of him. But I definitely think you have some interesting insight in terms of delivery, because again, whether or not you have a slam dunk case, it is still the prosecution's opportunity there to showcase their case and do it in a succinct and understandable manner. And you don't think he scored that victory in this closing?
I think he sounds like he's teaching accounting 101.
Well, there you go, Gary.
Yeah, that's what he sounds.
Well,
I mean, do you sense any passion in him? Do you sense he's talking about a crime that just rips you up? I mean, is he talking about that, or is he talking about debits and credits?
Like I said, I think he was certainly trying to be compassionate. Probably it didn't come across as well as he had hoped. But again, we're not in the courtroom, so sometimes these things come across differently when you're actually sitting there or you're in the jury box. listening to what's unfolding. But like we've said over and over again, this was never a question in many of our minds that this guy would be convicted, Donald Smith. The question now moving forward, and we talked a little bit about this, is we have the death penalty phase of the case. And Florida has some new rules when it comes to the death penalty. They have to have a unanimous verdict because of what was decided by a Supreme Court decision. And that actually held up this case for quite some time, several years in fact, because that particular death penalty case, another case, had to work its way through the court system and up to the Supreme Court. So they had to put all of their death penalty cases on hold. As we move forward to the second phase of this trial, what do we expect, Gary?
Well, again, the guilt or innocence is a non-issue. So now we're talking about the idea of redemption. We talk about the idea that there's some aspect of compassion exhibited by Mr. Smith that is such that the jury can connect to that, relate to that. And again, you got to get all 12 jurors on board with it. Now, you made a good point, which is the jurors have to agree before they can become jurors in a capital murder case that, in a death penalty case, they have to agree that they could find somebody subject to the death penalty. They could vote for the death penalty. That doesn't mean, though, they have to vote for the death penalty, and it doesn't mean that they're going to vote for the death penalty. You're still trying to reach out, and you're still trying to connect to the jurors, and hopefully at least a juror, and try to find that connection that, again, you bring up some sort of compassion and you bring up some sort of sympathy with your client. And you have to show there's something about your client that is worth saving. There's something about this client that is special enough that despite the monstrosity of this crime, the terribleness of it, which you concede, you have to say, look, this is terrible. He did a terrible thing, but we are above that. We can look to this individual and find something about him that makes the death penalty not the correct remedy, that life in prison without the possibility of parole makes sense. It provides our safety, but it also gives the opportunity for him for redemption, and we see something about him that makes that appropriate.
Well, I got to tell you, Gary, in watching this unfold, knowing what I do about his history and how he reacted in court, posing for the cameras, I just can't see a juror finding that redemption that you talk about, or finding it in their heart to just spare him. We've done quite a few death penalty cases here on the Law and Crime Network, and to my knowledge, so far we haven't had a jury vote for the death penalty because someone somewhere always found it in their heart that they wanted to spare this person's life. I just don't see it happening here. We'll see. I just don't. What's your guess?
If I were the defense attorney, the glass of ice water sitting next to me would actually be gin. I would be probably having a few shots. It's tough. This guy's a mess. And as much as there's some people believe that there are truly evil people in this world. And there are people who also believe in equal measure that, hey, everybody's capable of redemption. Everybody is capable of going, oh my God, look what I've done with myself, and change. And there are people who, I've met people who were terrible people. And clearly, I think they were sincere in wanting to make a change, and they were a different person. We've seen that. And we believe in redemption. That's part of who we are as an American people. We believe in the idea that people can do bad things and somehow get better. We rejoice in that.
So, Gary, I just want to give our viewers kind of a rundown of what we're expecting. In the next couple of minutes, we're going to bring in a local reporter who is actually in the courtroom when the verdict came down, and she's going to give us an inside, blow by blow, of how the jurors reacted, how the gallery reacted, and the sense of community there and what happened during the verdict. So we're going to bring her in a few minutes. Gary, if you don't mind sticking around for a few more minutes, because I want to continue our discussion about about this horrifying case. In the meantime, for those of you just joining us, we were in verdict watch for a very few short minutes, and 15 minutes actually, in the Donald Smith trial, the one we've been following out of Florida. And the jurors came back with a guilty verdict on all counts: kidnapping, raping, and murdering little 8-year-old Cherish Periwinkle. Horrifying case. The whole case started, and that's why I think it's important to play, with the testimony. She was the very first witness of Cherish's mother. Let's take a listen to some of that.